All right, so next panel, government as a platform. So I think that's a really interesting space for many of you. And leading the panel will be our residential fellow, Jameson Dempsey. And yeah, over to you, Jameson.
All right, thank you very much. I'm Jameson Dempsey. You may remember me from 10 minutes ago. This panel will be about a topic that I find fascinating, and I hope many of you do too. It's government as a platform, ways that governments are turning themselves into platforms, either by making data available for people, researchers to use, or by making their laws and rules computable. And we have a panel of international experts on this topic who have all been working on these issues for a number of years. And so I'll kick it off. We'll run down the line. I'll introduce everyone by name, and then we'll run down the line, and each person's going to give about 3 to 5 minutes of introductory remarks about who they are and what they're working on. So we have Leila Banijamali here from Symbiom. We have Meng Wong, who's the co-founder of Legalese. We have Matti Schneider, who's an international lead for a project called Open Fisca. And on the big screen, where is Pia? Can you hear us? Can we hear Pia?
I can hear you.
Great, excellent. And we have Pia Andrews, the Executive Director of Digital Government at the New South Wales Department of Finance, Services and Innovation. So Pia, maybe we'll start with you if you'd like to introduce yourself and share a little bit about your work for the next 3 to 5 minutes.
Thank you so much. First of all, thanks for having me, and I do wish I could be there in person. We just had an election, so there's a lot of work to do. Very quickly, I'll just make one comment of my 1 minute of my 3 to what I mean by governance platform. Governance platform is so much more than just open data. It's the idea that government needs to turn itself into the social and economic platform upon which society, economy, people can thrive. So the idea of taking our data, our content, our business rules, and indeed our transactional systems, transforming how we deliver and manage those things into modular architecture so they can all be available as individually unique components, and then having those components be available to myriad government services, private sector services, academia, everyone. The reason this is critical is because the complexity of change is growing exponentially, but the ability for any institution, and government is just another institution, the ability for any organization to respond is probably linear. So if you want to actually respond to exponential change, you need to create mashable government, components of government, so that many people can pull together different things to respond to that exponential change. So for me, open data was the start as a platform. The rules as code is probably the next big and most important part moving forward, particularly as we see more AI and artificial intelligence, machine learning and automation. It is critical for our rule of law and public trust to start to rebuild in public institutions, that we ensure that there is traceability, accountability, accountability of decision making, whether it's by a human or by a machine. So I'm going to quickly talk for my 2 minutes about rules as code and the work that we're doing in the New South Wales government. I will briefly say that I did a year and a half of this in New Zealand beforehand, and the work in New Zealand is probably leading in this space. So I refer to that briefly, but we also did some work in the financial sector in Australia prior to that. So rules as code. All of these slides are available. There's lots of words only so that there is references, but briefly, what is regulation as code? It's drafting and publishing rules from legislation, regulation and policy in human and machine single form. We shifted from the terminology of legislation as code or regulation as code because a lot of rules aren't actually in regulation or legislation, they're in all different forms. So rules as code becomes an overarching concept. So our current scope is focused largely on service delivery, on prescriptive rules, and on edge cases that become codifiable as precedent becomes established. So you might clearly see as precedents emerge that if you meet these criteria, then this precedent would be included or excluded. So you can start to take these fringe cases and codify them. But there's also a huge opportunity to collaborate with our Parliamentary Counsel's Office to actually update how we draft legislation and regulation in the first place, how we draft policy in the first place, to actually get test-driven regulation legislation and to get a high-quality approach to policy of our regulators in my jurisdiction were pulled together into a better regulation program, which is looking at the future of regulation and what digital transformation means for regulation, so we're working very closely with them. And we're also working around the idea that when you meet certain conditions where a judgment is required, for instance, you might have criteria of eligibility to be a citizen, but you still have to pass a good character test. Why not see if you're eligible first, and then once you've met those criteria, then you're referred to, okay, here's how you know, now go and get the judgment. So even where judgment is required, you still use rules as code as a giant switching engine, effectively. Why are we doing this? The problems we're trying to solve are fundamentally that legislation, regulation, and policy, not just hard to consume and define, but hard to draft. Second of all, that because of the increasing complexity that we're seeing and more rules just being laid on top of more and more rules, this makes modelling increasingly impossible and predictability of outcomes increasingly impossible. So we need a way to improve modelling. Thirdly, most rules are used by software, but the current cycle of interpret hardcode and update ad infinitum creates a huge consistency gap with how those rules are applied across the economy, and of course enormous wasted effort. We're effectively using lawyers as modems right now. There's analog input, they translate it into a digital output, someone implements it, and then at the other end, it's the reverse. So it's a bit cheeky to say this forum, I'm sure, but anyway. Fourthly, if we make the rules of government human and machine consumable and discoverable, then we can be more efficient in how we apply the rules and more transparent. And of course, service delivery draws on many rules across different acts, different jurisdictions, different authorities, and different instruments. Very quickly, the benefits then become about multidisciplinary teams get better policy intent realised through to implementation. That's key. Right now, policy teams and legislative drafters are completely separate from implementation, so the ability for that to translate through is not there. And modelling, of course, I've mentioned application. A lot of people don't think about faster deployment. If you create human and machine readable rules, then at the point where the human readable form, just a law, is enacted by Parliament, you can actually put an API out immediately. You could have a test API out beforehand. You could actually be testing those rules in the economy and in applications and in if they have the intended impact, and unintended consequences. And finally, which is probably the most important to my heart, is traceability, transparency, and accountability. There have been cases through the AI, machine learning automation, where we have seen injustice. We have seen undescribable decisions being foisted upon people and there being no recourse. So accountability of decisions is critical, and the ability to trace back the authority of that decision and traceability is important. Finally, what's not right, this is important for this room, it's not structured content. The amount of people have said, yeah, we're doing rules as code, we put it into a structured content, XML invariant. Most places we run around the world, and most places I still talk to, are just using interpretation engines, which are fine if you have to work from the legislation in its current form. We're going a whole step above and saying, actually, we want to draw a line in the sand and change how we draft it in the first place. Finally, it's not a website, obviously. A lot of people's expectations are based on not challenging the status quo. We have a fantastic and unique opportunity to work with the Parliamentary Counsel's Office and indeed our other regulatory stakeholders to actually change the status quo, change how we draft in the first place, and actually have an API to legislation of New South Wales regard.au. So we need to step up and start thinking about our digital by design, digital first approach to the rules of government. Very quickly, the status quo is this. You have the rules, people interpret many different ways, they apply different ways, and you end up with myriad implementations and myriad systems by myriad people. Very limited for use in interpretations, and government doesn't provide rules assurance. Companies or compliance or indeed agencies will use the rules. How do you know if it met it? You don't. So the status quo is very linear. I'll know in a couple of minutes. The future state is co-draft human and machine rules, test them, have a test API available, then at the point where it's enacted, have the API available immediately. Everyone can then consume those rules as code, which then leads to the ability to monitor for patterns of good patterns or bad patterns and the prioritization of regulation. There's more here. I only have 3 minutes. I'm pretty sure I've used up my 3 minutes. Well, stop there.
Excellent. Thank you very much, Pia. Lela, if you could introduce yourself and talk about what you're working on.
Sure. Thanks for having me here. So mine is actually not going to be as long as and wonderful as Pia's was. Let me say, first of all, big thanks. I think people don't say this enough to Roland for organizing this every year. I feel like you don't get enough credit for everything that you do. So thanks. And a little bit of credit to you too, but not as much as to Roland. That's it. All right, so my name is Leila Banijamali. I'm the CEO of Symbium. Symbium is the computational law company. We launched out of Stanford. I'm going to tell you what that means in a moment. We launched out of Stanford just last year, and we just closed our seed round of $4.1 million. So we're now launched in San Francisco. We're a small team, still all Stanford team, which is great. So what does computational law mean? It was actually coined by one of my co-founders, Michael Genezareth, who's a professor at the computer science department and also co-founder and director in research at Codex. And all it means is bringing laws and regulations directly to the point of human experience that Roland taught me to say so well. And an example of a computational law system that you're all familiar with is TurboTax, how the IRS tax code is actually baked into the workflow. So as you type, you get instant feedback on your tax obligations. So we build systems like this. It may have taken Intuit 6 months to a year to build TurboTax. We can build it using our platform in a matter of days without writing a single line of traditional code. And so this is a really, really exciting new technology and has many, many applications. And the one that we pinpointed that has the largest viability for us, the most important viability for us right now, is in the government space, and specifically in local governments, and even more specific in planning departments. So to give you an example, what we've done is we've actually taken planning code and mechanized it. And so our one of our first services, which you can actually see at build.symbium.com, is streamlining the accessory dwelling unit process. So as you know, housing in California is a major crisis, as it is in a lot of parts of the states. And California has required that all jurisdictions within California accept and review and either approve or reject the applications for accessory dwelling units, which is a fancy term for a granny flat or just a separate unit on your property. And these applications must be ministerially approved by these local jurisdictions within 120 days of receipt. And so here we have all of these state regulations now, and in addition to local jurisdiction ordinances, you know, the city ordinances, the city regulations, transportation regulations, regulations from the fire department on how many, you know, fire sprinklers you have to have in your unit, and all kinds of stuff like that melded together. And now we have these planners behind the counter who have to understand how to interpret these laws, apply them, and approve or reject these applications within a very short period of time. And so our build service enables us to automate this whole process to learn instantly, can I build an ADU at this particular location in this address? And if so, what are all of the development standards that apply? And it does so in a very visually appealing way, so you don't have to go to the planning counter, take a number, and manually have that planner go through the process of reviewing codes, reviewing legislation, trying to understand what all of the updates have been since, you know, a few weeks ago. In the case of the City of San Francisco, their rules get updated on a weekly basis sometimes. And you can talk to one planner and get one answer, talk to another planner, you get a separate answer from them. So we've essentially streamlined this process across, we're working across California right now. We've finished a few cities, and we're doing them one by one. So that's essentially the work we're involved in.
Great. Thank you, Lela. Meng.
Right. So my name is Meng, and I am co-founder of Legalese, which is also a computational law company. Not the, that's you, but we are a computational law company. Mark Andreessen says software is eating the world, and we like to say that software is eating law. And that is the motto of our little startup in Singapore, where my co-founder, Alexis Chun, and I, Alexis, do you want to stand up and say hi or just wave? Hi, that's my co-founder. We've been working to realize the vision of software eating law. And she's a lawyer, she's a recovering lawyer. And I'm a computer scientist and open source programmer who has spent hundreds of thousands of dollars in legal fees, which is what makes this personal for me. And so, what does software eating law mean for us? It means that you could maybe write unit tests, and you could run unit tests on your contracts or your laws, and you could say, this little tweak that we made just broke a bunch of tests, and we need to go fix it. It means that a user might be able to get answers to their legal questions not by picking up the phone and asking their lawyer, but by running software, by opening an app that does for legal thinking what a spreadsheet does for financial modeling. Because spreadsheets allow the automation of quantitative reasoning, but until recently there's been very little software that allows the automation of qualitative reasoning. And if you think about it, business people use Excel in a very different way than the way lawyers use Word, right? Because every time you press the equals button and you type in a formula or a function, and you set up a spreadsheet where you can run what ifs, you can explore scenarios, and you can see the changes ripple through the spreadsheet, and you can't do that in Word. But wouldn't it be cool if you could, right? If there was some sort of tool, and I think the kinds of people on this panel, my colleagues, are building tools to do exactly that. And wouldn't it be so we think it would be cool if you could do that for legal what-ifs, contracts and laws. You can say, am I allowed to do this? And what happens if I do this? How do I get there from here? These are the kinds of questions that people have traditionally asked lawyers, but I think in the future we won't have to do that. And so it turns out that there's been decades of academic work on these ideas, and as a Codex fellow here last year and as a Berkman fellow at Harvard before that, I've been following a hunch that the way to realize some of these ideas is it begins with a domain-specific language for law, sort of the way SQL is a domain-specific language for databases, sort of the way that Adobe, their first product was not Photoshop, it was a domain-specific language called PostScript. So something like a spreadsheet, but for legal reasoning, would be the basis for building apps like what my colleagues here on the panel are doing. And so in Singapore, Alexis and I have been working to develop just such a DSL, which would allow you to compile 10 lines of code into 10 pages of PDF. And you could represent laws in the language, as Pia has talked about. You could represent contracts, and it would be machine interpretable so that you could run tests against these programs. But it would also compile to natural language so that you could write your code, you could write your law as code first. You could write your contracts as code first, and then compile it to something that humans can read and judges can interpret. And so this is what Pia talked about, and it's very similar to these kinds of things that I'm sure you'll hear about from Matti and Lela in more detail. And along the way, Alexis and I in Singapore have been experiencing Singapore's government as a platform strategy, which we just heard about. And we are a beta tester of one of Singapore's government APIs. The government has actually hundreds of data APIs and application APIs available. For example, I learned this the other day. Every single tree in the country has its own row in an SQL database. You could go to trees.sg and you could query that database and you could find out, hey, I was driving down the road and that was a really nice tree. What is it? And it would tell you the species and how old it was. Like, that's pretty amazing. And So that's the sort of future that we want to build, being able to interpret laws and contracts, but also work with governments to make all of this stuff open. Because as an open source developer, I really believe that having this stuff proprietary is not healthy for the relationship between government and its citizens.
Great. Thank you, Meng. Matti? I think it's on already.
This one?
There you are.
All right. Yeah. Hi, my name is Matti. I'm very jealous not to be on the giant screen here. It's okay, so my biological clock is currently set at midnight, so I might be a bit too long. Don't hesitate to wave at some point, right? I'm coming from Europe, from France. Thanks for the invitation. I'm not a legal tech company. I never set out to do legal tech. I build public digital services. That is, I improve the relationship between citizens and government through digital tools. And for that, in 2014, I built for the French government, within the French government, a hiring cost assessment tool. That is a website on which you could define how much would be the cost for a new employee over a full year. And in 2015, my team built a benefits entitlement assessment tool. That is another website on which you can describe your own family situation and know all the different benefits you might be entitled to, given by so many different agencies that do deliver them in France. It just happened that we used the same computation engine for these two apparently very different goals. It was open source. We open sourced it. It's called OpenFisca, as in fiscality. And at some point we realized that it was quite powerful and that we could build other types of services on top of it. Its specificity was that it's aimed at collaboration, right? It aims at bridging the gap between developers and lawyers, or at least people who read legalese and people who read code. What makes it quite special compared to most other solutions is that it does not try to address only the issues that people who can read legalese have with code by trying to abstract away code, or on the other hand, to help developers understand law. No, what we do is bring sets of tools and practices that enable collaboration, that helps these people get together in the same room, on the same table, and actually make law understandable by machines. So we presented that tool into 2016 at the Open Government Partnership Hackathon, and it did work quite well. Actually, within 36 hours, we were able to model the income revenue tax for an entire country. And that made me take the lead of that tool in 2017, where we scaled it internationally and launched openfisca.org, whereas this tool was previously mostly focused on France. It's now used in 8 different countries, and its aim is to be a common. So the code itself is open source, but we also have an open governance. And the aim is that each country has its own set of open source rules as well, so that each country builds upon a shared engine, improves on it, and that anyone can contribute to rules in their own jurisdiction. So that's the main example of my work in legal tech, but as this panel is on government as a platform, there are quite a few other initiatives as well. But I guess we'll touch on that later.
Thank you very much, Matti. So all of the introductions raised a number of, I think, interesting issues and interesting questions. And the first one that comes to my mind is, how do we get from where we are today to government as a platform? And so maybe if I could start once again with Pia on the screen, how do you train today's public servants to build these systems, to work with these systems? Does it require bringing in new talent, or is it just about upskilling the existing folks who are working in government?
Thank you. That's actually a really good question. The simple answer to that is that there is a number of things that need to be done. First of all, we need to address culture. A lot of people, this is not just in the public service, but a lot of people see technology as something that is someone else's problem. They outsource even thinking about it to their favorite geek. In the case of a large organization, the favorite geek might be a CTO or a CIO or a CDO, but people outsource thinking about it. So actually redefining what it means to be a modern public servant and looking at the core capabilities of a modern public servant to include a digital literacy, to understand agile and iterative design, human-centered design. The basics of all of these will actually help, and data, of course, data literacy. The basic of getting these cultural change would be quite powerful. So our public sector commissioner in New South Wales is looking at how to actually get all of public service digital mindset to be normalized. Because that then creates both the supply chain but also demand for the government as a platform. The second thing is looking at how we build. So the introduction of service design has been very helpful in some ways because it's started to reinstitute empathy and reinstitute services that meet people's needs, and it has forced a break from traditional monolithic large systems. All of the introduction of web into government over the last 15 years open government is a critical foundation for digital government. It's not just about changing how the public service works and insourcing or outsourcing or bringing people in or outsourcing. You need to do all of these things. But if it's not done openly, if we don't change the way that government works to be more collaborative, transparent, public, release early, release often, if we actually introduce and normalize open source culture into open government and into government generally, that would probably be the biggest enabler of government platform.
Terrific, thank you. So I'd like to ask the rest of the panel, when you're working with governments, and maybe I'll start with Matti and Lela, maybe Lela if you want to kick it off. When you're working with the government of San Francisco, is the process, give us your laws and rules, we'll make it computable, and then give you something back? Do you work collaboratively? What's the process, and what are some of the challenges you faced in that process?
Yeah, so the process is, the laws themselves are innately open because they're published, so they're accessible by anyone. Otherwise, how would we know how to comply with them, right? So we have that available to our advantage, and that's sort of the foundation of what we need in order to build systems. The nature of what we're building works best. Computational law typically works best in non-discretionary systems where there's no subjectivity involved. There's a major difference between, these two buildings should be at least no less than 10 feet apart versus these two buildings should not be too close to each other. And so if we're able to make that in a computable form, then that's what we can do quite well. And we can deliver that outcome to the constituents better than a planner can deliver it manually because of the fact that it is black and white. And you shouldn't get a different answer when you go to the planner sitting at the next counter. So the collaboration that's involved in these processes, similar to any computational law process, whether it's in government or insurance or financial services or legal services, is there should be a collaborative approach taken here. And the planners are critical in areas where, there's conflict between the laws, and we need to understand how to resolve the discrepancy. B, the data was not maintained by the city, which is often the case. And in that case, we actually build tools to help these cities clean up or obtain the data that was missing. Some cities don't maintain, if you can believe it, a digital zoning record of their cities. And in some cases, we've actually created that tool for them just to get them to the place where they can actually start using our services. So there is a two-way path here where everyone benefits, but it is very much a collaborative approach.
Thank you. Any other thoughts on the process? And if not, the follow-up question I have goes back to openness. A number of folks on the panel have talked about open source. If you're working, Meng, for example, with logical spreadsheets, these kind of spreadsheets for law, should those be open so that people can look at them, or should they just know this is something that you can trust because the logic is already in the law?
Yeah, it's interesting. Spreadsheets are open in a way that a program such as QuickBooks is not. And when you talk about collaboration between the public and private sectors, I think sometimes that can be taken as a euphemism for regulatory capture. And I know that a few years ago there was a lot of news about how maybe it would be a better idea for programs like TurboTax to be done as a government service. And that is in fact how things are done in places like Singapore. I mean, I just started to file my taxes today, and it's one web page, and you can type in your credit card number. It is a government web page. It's not a private sector web page. So the idea of openness, I think, is very nuanced. Being able to have all of these regulations come out of the government in a machine-readable form is very different from a private company that translates these things into a machine-readable form and then just resells it. So I think having things open as early up the chain as possible is a good idea. Carl Malamud at public.resource.org has been banging that drum for a long time. So if you don't know about him, go check it out. Public.resource.org says that the governments that make the laws should not be allowed to copyright the laws.
Matti, any thoughts on that?
Yeah, I guess to me the main question is what is authoritative? If the law in legalese is authoritative and you can just derive some interpretation from that, then it might be done by the private sector. But if the end goal is to have governance as a platform, that rules are enabled, are available through APIs, then it means that the computation version is authoritative as well. And to me, at least from a European background, it doesn't make sense that this would be delivered by private entities, right? If we are all to abide by some interpretation in code, that should be enacted by government. And as for transparency, this should be open source. Like, how are we supposed to abide by rules that are not freely and easily available? How is that even thinkable, possible? So to me, it's like, it's part of the definition.
Great.
May I?
Yes.
I just want to make that comment on that as well. I think there's lots and lots of companies doing really great work, and with different, some are doing it for very philosophical or good reasons, some are doing it just to make some money, and sometimes both. That's fine. But this question very rapidly gets to what's the role of public sector? And in each of our countries, across the 4 countries at least we've got represented in the panel, there's 4 slightly different approaches. So in Australia, we probably have outsourced a lot of functions to the private sector, but there's still a key functional fundamental role of government. And one of the concepts of government as a platform is it gives you a chance to differentiate between the delivery mechanism and the things that are substantially the authority of government to run. The data that is government, census data, or legislation is a good example, I think, of a role that no one else is going to tackle. But then you have the way that you deliver it. Government can still provide a service, so that there's always an upward push. You've got a feedback loop. Sorry.
That was the dub remix.
Okay. If government doesn't provide services to people.
Oh, we've lost Pia.
Maybe that was the end of her sentence.
No, I don't. Pia, you're back.
Let me try something.
Okay.
There's a feedback because of someone else's sound. So the organizer just turn off maybe Susan's.
Okay.
Susan on mute, she's in the room, I think.
Yeah, Susan. Go on mute. All right. Let's try. Collaborative Zoom, collaborative tech support.
I can speak slower, but I don't know how. Sorry, I'll keep it short. Being really clear about the role of government then creates the highest level policy for what you can do with government platform.
Great, thank you. We've been talking a lot about the positives of government as a platform. I want to turn to some of the potential risks. So both the risks of computational law, but then also in the time we have left, because I want to give an opportunity for everyone to ask questions if you have questions. But also on the data-driven side, we've heard a lot about algorithmic bias. And so maybe I'll turn it to Matti and ask, what are some of the risks of computational law, and how do we address them?
Well, in order to answer that question, you would first have to define precisely what computational law covers, so that's kind of a hard one. So for anything related to machine learning, so all the non-100% clear and all the stuff that you need some jurisprudence to build upon, of course. There's a sample bias, there's the risk of training models on decades of obsolete judgments that would be made different if done today by humans. So that's one part that I believe is quite well documented. One of the issues that you might have in algorithmic writing of law, so what we usually call legislation as code, or as Pia puts it quite well, rules as code, is the fact that you have an interpretation that's written in the machine, right? So just like there is room for interpretation in the law, and legalese is supposed to leave some room at appropriate places for humans to interpret. when you make that readable for a computer, there's no more ambiguity. There can be no ambiguity. So one of the risks is that you are entrusting the decisions that are going to be made on millions of people and millions of cases to the minds of 1 to 2 to 3 to 5 people who are actually writing that code and then reviewing it. So, I mean, it's all a matter of how do you review and make sure that there's appropriate ways to correct that. This is not specifically a risk, but actually a workaround or a compensation of that risk. Is it? Yeah. I want to stress that under GDPR regulation, there's quite an interesting point. Is that any person under GDPR jurisdiction, and that's not only EU citizens, it's actually all the other countries that are transcribing in their own national law GDPR, and that's becoming more and more frequent now. Under GDPR provisions, any person has the right to opt out from automated decisions being made on their behalf or on them. Anything that can have legal consequence that could be made by computers needs to be also possibly done by humans. And I think that this provision is extremely powerful in that by protecting one individual potentially from this type of automated decision making, it's actually and making sure that we will always have humans that know how to reinterpret these rules. And that would be, to me, the major risk. The fact that a decision, not even necessarily through machine learning, which through a black box, but even a very complex white box algorithm would be impossible to be made by humans anymore, right? That we would always be reliant on the machine. So that would be, to me, the main risk, that we become totally dependent on computers. And luckily, there are already legal workarounds that make sure that there's a way to go back into manual mode at some point. Right.
Great. Meng, any additional thoughts on potential risks or even limits of computational law that we either can't go beyond or shouldn't go beyond?
Yeah, I think there's all kinds of unintended consequences that could happen when you automate and mechanize bureaucracy. I think we can all imagine sort of nightmare scenarios. But does everybody know about the Cobra effect that happened in colonial India under the British, where they said, we want to reduce the number of snakes out there, so we're going to offer a bounty on every dead cobra that you bring in. And so that worked for a while, and then it turned out that people were breeding cobras to bring them in. And so then they said, that's not such a good idea, so we're going to cancel the program. And so the people who were breeding the cobras now said, I guess we'll just let them go. And now you have more snakes than you did before, right? And if you sort of apply the thinking of what computer security looks like, right? Hackers are always looking for security holes that they can exploit. What we're doing is we're creating an environment where you can automate the exploitation of these kinds of holes. So maybe that's something that we need to think about. And perhaps the best people to think about these things would be science fiction authors, people like Cory Doctorow and Charlie Strauss. Maybe we should invite them to the panel next year.
That'd be pretty cool. Lela, any additional thoughts on either the risks of computational law, government as a platform, rules as code, or the potential limits of them?
I always have thoughts, Jameson.
Great.
So with regards to risk, I think the biggest risk that was probably already mentioned is the humans that are in the loop. I think that could be very risky from a computational law perspective. Computers are really good at what they're fed, but they're reliant on humans to feed them that loop. And what we've known as the risks in, let's say, a particular kind of AI like machine learning, which is very, very popular these days, people seem to throw that around a lot, is that it works well with very large data sets, and where there are no hard and fast rules, where we try and infer the rules from previous interactions. Where we have all of that data, we can come to that conclusion that this is the best approach. This precludes what we call sort of unicorn instances or outliers, for which we've never seen before, and there's no real good data about them. And so that's when it doesn't work well. There's another type of AI that's what we're focused on, which is a knowledge-based AI, not a machine learning AI. And that knowledge-based AI is directly on point with, what the law actually says. And we're not reliant on, it's basically the very sort of black and white, non-discretionary portions of the law. And so I think the two are complementary in many ways. But I think the risk is actually humans. We shouldn't be talking about risk from certainly there's a risk from a mechanization standpoint, from a computable standpoint, but there's a much greater risk from what we've seen from humans that are providing these manual services on non-discretionary issues.
Great. Pia, any additional thoughts? Do we have you back on the Zoom, or have we lost you?
We do.
Okay, great.
And we think you figured out the feedback loop.
Wonderful.
So I guess I have 3 cautions and 1 optimism. The first caution is closed source decision making. So one of the challenges we've seen already is myriad automation, machine learning, and AI decision making, where you can't tell how the decision was made based on what authority, based on what data, based on what rules, and whether it has authority, of any sort. So, and that's both the case with emerging tech and old tech. So, but that will get bigger and faster and more complex with more automation. Going to Meng's earlier point, hackers aren't just people; they're also machines in terms of crackers. So the people that break into systems as opposed to people that make software. Anyway, people will build a lot of safeguards around the concept there's a person that will do something that we can then identify and we can go and track and punish them. We've seen AI Phoenix companies, but a Phoenix AI could spin up a company, transfer data, shut down the company, and move on in microseconds, by the million. And a lot of our systems are still assuming there's a person involved. And so we need to almost shift our paradigm in our thinking, because otherwise some of these new things will actually just speed up those opportunities. From a limits perspective, we don't think that this applies to justice. We think it applies to rules at this point, certainly. So where it's prescriptive, where it's clear, and where there are clearly defined exceptions is where this fits well. That also frees up, arguably, bureaucracy and resourcing to better apply time and actual justice and actual law. The final thing I'll say is the risk. People love to look at the risk of change, but actually there's the biggest risk of the status quo. A lot of decisions happening right now that are and wrong. I'll give you a small example from New Zealand, our experience just coding some of the rules that were all found in legislation, all had a legislative authority, or some of the entitlement system over there. We found one particular entitlement that had rules around parental access, so a mother's access to maternity pay. And what we found was when we codified it and ran test strips, we would throw hundreds or thousands of regression tests of use cases at the rules to see what impact it would have for different profile types for different people. And we found fairly quickly, if something happened to the mother and the partner, whether it's another woman or a man, was left with the baby, holding the baby into birth, then they didn't have access to that money, and that would be bad. So we let the agency know, the social welfare agency know, and they said, yeah, it's a known problem, but we can't do anything about it. Tragically, a month later, that happened. A woman died 2 weeks after her baby was born. The father was left and was a small business person and couldn't afford it, and it was a big issue. The Prime Minister said, this will not do, and they decided to go and change legislation. And the people doing the legislative drafting actually came to our regulation as code, rules as code team and said, you guys pick this up. You need to make change anyway. What other changes do we need to make to improve equity of access? So just as a good news story, the current status is not great, and the idea that the change might be worse is possibly not always to assess the risk of maintaining the status quo and the inequities that the status quo has already proliferated.
Great. Thank you very much, Pia. I want to ask one final question, and then we'll turn it. And so this will be like, if you could answer in like maybe a tweet, maybe 2 tweets back to back. But so the question I have is, what's the implication of, or how will rules as code or computational law, government as a platform, impact the role of lawyers and how we should train lawyers for the future? So maybe I'll start with Lela. I'll make our way all the way down, and we'll end with Pia.
So the impact on lawyers, I think, how, maybe I'll talk about it not just from the impact of lawyers, but I think all professions need to start thinking from a technologist perspective. So perhaps in the law schools, we should be training, law students as technologists. And similarly in other professions, as someone mentioned earlier, that one profession can't be another profession. Well, I don't think that's true. We've had many people on our team that have added a lot of value by being multi-vocational. And what was the second part of your question? The second part of my tweet. Yeah. Impact on lawyers, and then how we should train them for the future. You answered the second part. Oh yeah. So I think helping. I think enabling people to build things in a much more lightweight fashion. So I think that's part of what we're trying to do too, is new ways to code. So I think that's what we're interested in.
Great, thanks. Meng?
Yeah, I think there's a fair amount of legal advice that is actually business advice. And I think future lawyers will have to be clear about what they're doing and what hat they're wearing. Are they wearing the hat of a lawyer who is allowed to represent somebody in court, or are they wearing the hat of an experienced business person who would like to give you some advice about a situation that many other people have faced in the past? And we're beginning to see the legal profession under attack from people like the accounting profession, who are starting to open basically legal service firms inside an accountancy. So I think these kinds of things are going to change, and software as a sort of force multiplier for people doing what-if scenario planning or outcome analysis. I think those aspects of software law and legal software will make it possible for the end user ultimately to start answering a lot of questions on their own without ever aiming for legal advice. Business advice, maybe, right? But legal advice, if it is, as you say, determinative, if there's no room for interpretation, why do we need to ask a lawyer to basically read you the law, right? Why do we need to ask a lawyer to read you the contract when you could read the law or the contract yourself?
Thanks. And Matti?
I will expand lawyer to notaries, drafters, basically people who are experts in legalese, if that's fine with you. Mm-hmm. So one tweet. Less automatic work, more automated work, probably less interns, and higher value services to be delivered and built upon. Learn tech. Doesn't mean learn to code, but learn to consider that technology is not someone else's job, but it's actually becoming part of yours. Employ developers or get ready for disruption. It's not a threat, it's just what happened everywhere else. There are major opportunities, but those who rely on a niche market where they are the only ones to have some specific knowledge, some specific language, this know-how is going to be much, much more accessible. And if that's your only vantage point, you're going to lose it.
Thank you. And Pia, do you want to round us out?
Yeah, I can talk in tweet, so I'll try.
It's all right.
First, from a skills perspective, learn design thinking and technology for sure, and the difference between prescriptive and trying to shift people back to more prescription where it's possible. I think we've gone through a huge cultural shift towards let's make everything principles-based, but then that made more confusion and less access to justice. But in the how to prepare for the future, I think we need to think beyond the legal sector. We need more legal literacy in schools. We actually need to ensure that to go to Mandy's point, that our policy people, our drafters, and our technologists and our designers are in the room at the same time to develop the foundations of our legal and sector foundations for society. That wasn't quite a tweet, but I think that's an important note. I think that too many people get stuck on how do I train for that person or type of discipline, but we're all in this together. So the key thing is to learn how to collaborate and be open to the idea that people that are not a lawyer might have something to contribute to your sector. The same with the scientists, the same with the technologists have had to learn. Designers and technologists are at war to start. We're just getting them working together and the outcomes are found. So multidisciplinary skills are genuinely critical in test-driven legislation, law and regulation.
Fantastic, and I couldn't agree more with all that. In fact, as Roland mentioned, I think our themes are openness, global, and then collaboration. So I'd like to thank the panel. If everyone can give a round of applause to the panel, really appreciate it from around the world. If anyone has any questions, please approach the mic now. Appreciate it. And then before we hop into questions, and people can feel free to walk up if you have any questions right now, is we're actually teaching our first Law as Code course next fall here at Stanford. It'll be a computational law standalone course based out of CS but cross-listed with law. And so we're really going to try to take strides toward this future training of lawyers for legislation as code. All right, we'll start with a question right over here.
Thank you. I would like to talk a bit about dangers of making computational law or making laws through algorithms, or even making such a database that would simplify a lot the process of access to legal data or to eventually to rules. The problem is that people are lazy and lawyers are lazy also. Several researchers raise the matter that even more than doctrine, which is technically the source of law, the law practices are influenced by templates of contracts, by these templates that people just use. People don't want to do it themselves. They don't want to pay lawyers. They better take something preset, prepared for them, and just fill in names and data and sums. Same thing with legislators. I analyzed a lot the tax laws of different countries, and several times I noticed that there are exactly equal, similar pieces of laws, and that happened without any framework of harmonization or unification of law. It was just a copy-paste that some assistant of legislator used because he wanted to go home earlier to meet friends or something else. So he just copy-pasted, and then it passed through all the steps of legislation. So my point is...
is there a question or just a point?
No. Now, okay. And now here
okay.
is the question. Yeah. Don't you think it's rather dangerous to allow a computer to even make prepared some algorithms that can become law, even though the eventual decision will be taken by people? And the same thing with these law databases, because the database somehow sorts and classifies the data. And the way you classify definitely influences the decision of court, law executor, or anyone. So do not you see it as a dangerous...
Dangers of I think we had a question about the risks. Do you have anything else to add about risks or dangers of computational law? Pia does, raising her hand from afar.
I'm sort of aware my head's huge, so I'm trying to avoid that. I think that, first of all, the question conflates data, rules, and algorithms. Making legislation available as code is not making a decision about law. And law and regulation, you know, people use the terms interchangeably sometimes, but I think we need to be quite clear here about the difference between justice and regulation or some forms of legislation. Making the rules available as code is not how they're applied. We've been very clear about making prescriptive rules available in a way that anyone can query, which then creates myriad opportunities for anyone from an NGO to sort of right through to a company or government to use those same rules. But the way they apply
Thank you very much. Okay, we have 3 people who want to ask questions. Roland, we have how many minutes left?
We have 3 minutes left.
3 questions, 3 minutes. Here's how it's going to work. You have 30 seconds to ask a question, 1 sentence that ends with a question mark, and then you can direct it toward one person who then has 30 seconds to answer that question.
All right. So to whoever wants to answer, the question I have is around what happens when you have rules which conflict. So, for example, if a self-driving car is blocked on a road and it's a double yellow line, it's going to be stuck there forever because it can't cross the line and it can't drive through the truck. So how does that, like, does the same thing apply with government rules, and how would you simplify or handle that?
There's a whole theory of defeasible logic that deals with rules and meta-rules and prioritization. And so one of the cool things about computational law is that we can, at compile time, we can statically analyze to detect situations which are unruly, where multiple rules do conflict, and then we can explicitly say, please prioritize.
Cool. Thank you. There's the answer. All right. Carl.
Yeah,
Okay.
Oh,
Great discipline here.
Yeah.
Okay, in the form of a question, how much thought have you given to the knowledge representation perils that come from, as you said, the people who study law observe, or there's a whole literature about the defeasible, temporal, deontic character of rules combined with the fact that there's no unique logical representation in general of a given textual representation. So I understand that enacting something in computational form that's the institutional approach to that, but it doesn't eliminate the fact that there is no unique logical representation for a given set of deontic consequences that you want. Thank you.
Limits of logic. Who wants?
Yes.
Yeah. All right, and our final question.
No one will want to answer this, so whoever can, fine.
Sure.
I'm a librarian, so I care about accountability and transparency, but I also care about privacy. And in our current systems, we had privacy via obscurity. If you're moving the government to an e-platform, how do you prioritize keeping sensitive information outside of, on the other side of the paywall or the firewall, whatever, et cetera?
No.
In fact, I'm going to say, so if it's okay with Roland, what I'd like to do is if we can run like 1 minute over. This is a really important question, and I feel like if we could give someone a chance to answer.
No, Pia, I'm having this one. You've had too many. I think there's a confusion between all the different aspects, like as I stated earlier, between computational law and so this question is extremely relevant for all the jurisprudence. So, but for example, in all the rules as code, there is absolutely no personal data. There's only statements about what should you do with that data. So data is treated as an input, and it's only between one entity that's providing this data and the entity that's going to process it. So there you can have perfect security and privacy. Now, this question is very relevant indeed for big corpuses of data that will be open. And for that, I believe that we have, as a community, enough experience in opening data sets with proper safeguards in terms of redacting information, because there we are not trying to make decisions on the spot. Right, we have all the time we want to open a big data set, so we can write all the code, we can spend all the time that's needed to make sure that there's no personal information before opening that data set.
Okay. Thank you very much, and once again, a round of applause for our panel. Thank you.
Thank you so much for the great panel. So we're now 11 minutes behind. Let's try to bring it back to 10 minutes and meet at